It's been just over 2 years since the world's most watched and reported on trial began. The Oscar Pistorius saga spanned 49 court days, with the judgment successfully taken on appeal to the Supreme Court of Appeal by the state. Pistorius then floundered in his subsequent application to overturn the SCA murder conviction in the Constitutional Court. Having spent a year in prison, released on correctional supervision, and now out on bail for murder, it all comes down to his week-long sentencing procedure before Judge Thokozile Masipa. Arguments in aggravation and mitigation of sentence will be heard, but what does this all mean? And what factors will Masipa have to consider in deciding on the Blade Runner's sentence? We asked constitutional law expert advocate Mark Oppenheimer to place himself in prosecutor Gerrie Nell's shoes and explain how the state is likely to push for the harshest sentence.
So the underlying principle is that there are three factors that play a role. It's called the triad of Zinn. The first factor is the nature of the crime, the second is the position of the criminal, and the third is the interest of society. So as Gerrie Nell, it's quite important to focus on the fact that the crime was of a violent nature, that Riva Steenkamp was in a helpless position at the time that she was killed, and that the bullets that were used were particularly brutal bullets. They were zombie stopper bullets. That will be the kind of evidence that he'll want to use to show why this is an aggregating factor and why a higher sentence ought to be imposed. So with regards to the nature of the criminal, the defense will want to say that Oscar is a vulnerable person who's going to have a particularly hard time in prison. And with regards to the interests of society, it appears to be the case that after the 5-year sentence was imposed initially, that people were up in arms. They were very upset and felt this was a low sentence. Gerrie Nell may want to draw attention to the fact that people were dissatisfied and felt that the interests of justice weren't served, and that a higher sentence on that basis ought to be reached. And so Gerrie Nell may want to draw on all the evidence possible to show why the highest sentence possible is what's deserved in these circumstances, given that a vulnerable woman died at the hands of her lover.
The role of the defense counsel will be incredibly important as advocate Barry Roux seeks to mitigate or lessen whatever sentence Pistorius could get. Advocate Sello Alcock explains.
In simple terms, the test is you have to consider three things. The offender, the crime, in other words, the type of crime that did, and then the interests of society. So it's really the offender, the offense, and the interests of society. And when you argue mitigation, one typically then takes those three factors and marry them to the particular facts of the accused. So pretty much in saying, in this case, what is it about the offender that the court should take cognizance of that would allow a court to give a much more lenient sentence. And you'd also look at the interests of society in the sense that would it benefit society to send away, for example, on the particular facts of the Pistorius case, someone who's disabled? That is a factor I would imagine would play a critical role, and we would ask the question, it would be two factors, the offender plus the interests of society. Is it in the best interest of society for him to be put away, given that he's disabled, he may have a particularly harsh time, and we know our jails are not the greatest in the world, and what else would they do to make his stay in there comfortable? So you, as a defense, counsel, you'd hone in on those particular areas. If I were in the shoes of let's say Barry Roux, as you put it, I would then hone in on the fact that yes, it may be a serious crime prevalent in our society, but I'd also then put factors forward on why, in that particular case, we ought to the case law says that we'd have to put a measure of leniency or mercy. It must be tempered with some mercy on why the court ought to really fine for a more lenient sentence, for lack of a better word. I think it's very well a factor that one can put forward, given the fact that someone came and testified. There was a psychologist, and she came and she testified. It's already part of the record, and we know that there was a finding around this, his psychological state of mind. And I think you'd find that as a defense counsel, that's a factor you very well want to also show fitting with the offender, as I said, the offender, like saying, here's why we ought to treat him slightly differently, because of I think the psychological state, the social anxiety disorder that since childhood, because of the fact that he was obviously disabled, how that affected him.
Once again, the world's media attention will be focused squarely on Judge Thokozile Masipa. As a former acting magistrate, no one knows the pressures of sentencing someone more than criminal law attorney Marius du Toit. He says balancing justice for the Steenkamp family on the one hand with an appropriate sentence for Pistorius on the other is a very delicate act.
So depending on the gravity of the offence, depending on what the public feels out there about these sort of offences, because remember, any sentence you give would be a stern warning to would-be offenders, or would, in other words, if it's not a heavy sentence, would most probably encourage people to say, well, we can get away with it. Look at the sentence that's being imposed. So the court seized with a matter of this nature will have a very delicate dance that they have to perform in order to satisfy all these requirements and make sure that at the end of the day, by blending the sentence with mercy, keeping in the principles of rehabilitation into consideration, and looking at all the personal particulars of Oscar Pistorius, will then arrive at a sentence which I believe would be a blend of all of that and maybe take a middle ground of sorts. I've been privileged, Mike, in the sense that I was prosecuting and I also acted as a magistrate, and as a result I've sat on all three sides of the fence. Being a magistrate, I think, is a very lonely place to be, and that of course applies to a judge as well. I mean, when the sentence is handed down, the buck stops with you. But the only difficulty being, of course, that your sentence or the verdict that you arrive at will be scrutinized by other courts. And the courts are sensitive to the fact that sentence is a very personal matter. They're sensitive to the fact that it's not an easy process, and the courts therefore do interfere with sentences where they believe the magistrate or judge was wrong, where it was a startlingly inappropriate sentence that was imposed, or hard, exceedingly harsh, or something to that effect. So applied to the set of facts, when Judge Masipa considers it, she will of course have to try and strike a delicate blend of all the factors. There's a minimum sentence of 15 years, not a maximum, a minimum, which means the court can depart either upwards or downwards depending on the gravity or the mitigating factors placed before her. If she feels that the circumstances really justify a heavier sentence, then she has to place those reasoning or those arguments on record, and then she has to impose a greater sentence. She's got a delicate dance to do, in the one sense, keeping in mind that we have a person that's already served the term of imprisonment, the fact that he's already been on trial publicly for such a long period of time. His life has been ruined as a result of this. I mean, he is unable to partake in sports as it is presently. His athletics career is over, and nobody would want to touch him with a broom at this stage in the athletic environment. On the other side, you look at the fact that here's a person that has murdered somebody, not just negligently caused their death. And that's, of course, much more serious than just culpable homicide.
While no one can preempt just what sentence Masipa will be handing down, I asked each of the commentators to venture an educated guess.
I think in all likelihood she won't be able to find substantial and compelling circumstances which will lead to a sentence closer to the 5-year end. I think she's going to feel that it has to be somewhere between 5 and 15. I think it's going to be much closer to the 15 front. The safest bet is going to be 15, because she can then just say that's the minimum sentence, that's what I'm going to impose.
But I think we can maybe move towards, I think, about 10 on the 10 years end. I think that it wouldn't be too, because the other job that Judge Masipa has to take into cognizance is the interests of society, as I've said, and what message would the sentencing of Mr. Pistorius, she has to balance that. Will society find, and I think if I had to hazard a guess, I'd quite comfortably think that a 10-year sentence.
So I would effectively say, given those circumstances, I'll give you 10 years imprisonment. Keeping in mind that we're not talking about a severe degree of dolus eventualis, and I've already sentenced you previously for culpable homicide with a severe degree of negligence. So finding a blend between that, I'd most probably look at 10 years effectively.
As is so often the case, and is of course their right, no matter the sentence handed down, either the state or Pistorius has the right to appeal. What is certain now, though, is Pistorius will be back behind bars, but for exactly how long, that remains the question.